overview of things. We talk about wills and guardianship and powers of attorney and living wills, and then of course the special needs trust idea. I normally tell people, I'll give a little bit about a background about myself, but I figure since I came from more than 50 miles away, I'm already an expert, so that's not true. I claim no expert status. Anything I've got to share, I learned from my son Mike. Some of you, I understand, have met. Mike is 27 years old, and thanks to him is why I'm here today and why I do what I do. I went to Bellman College. Back then it was a college, now we call it Bellman University. And then the University School of Louisville Law School. And I worked for about 15 years in the city law department. And long about, I guess it was 96 or so, I'm not sure on my dates, but somewhere in there. My son Mike and my wife were in a car accident. Fortunately, everybody came out of that relatively okay, but there was a little bit of money that came out of that for Mike. And that's what got me going down this path. I thought, what am I supposed to do with this? Well, I started doing a little research, and I learned about this brand new thing called a special needs trust. Special needs trusts were only invented, if you will, or came into being in 1993, so they were brand new back then. But I learned a little bit about it, and we fixed up one for Mike for that little bit of money we had for him. Then a few friends said, well, we want one for our child, and then somebody else said, well, we need one too, and the next thing I knew, that's what I was doing. I will tell you, it was a game changer for me, and it's been probably the most rewarding thing that's ever happened to me, because I've got to meet lots of wonderful families like you all. So for me, I'm not doing city municipal work anymore. I figure I'm in the family business. So that's why I'm here talking about this, and that's really what got me started doing it. I usually like to find out who I'm talking to. Tell me about your children. I've met some of you, but tell me your child and how old they are. Let's start with you all.
Jonathan and Renee Estes, and our daughter's 4.
Yeah, that's who we saw running around here.
Yeah. We sent her to daycare.
The little cutie.
We have 3 other kids.
Great. Anybody, just tell me how old your child is. That's what I want to know.
14-year-old daughter.
Great.
I'm an 11-year-old.
11-year-old.
6-year-old.
6 years old. All right. Carla.
I don't.
All right.
I just love everybody else's.
We have a 15-year-old son.
15-year-old.
I have a 34.
Yeah, you told me about that. Who else?
I have a 7-year-old daughter.
7-year-old.
9.
Well, that's wonderful. Mike is 27, and like I said, we're still learning from him, and I'm sure all of you are learning from your children. And, one of the first things that ever really struck me, we were sitting on the couch one Sunday morning, and we were eating Winnie the Pooh. And I'll never forget it, because we were opening the picture, and the rabbit, I've forgotten the rabbit's name. Y'all probably know who I'm talking about. And the rabbit was in this picture, and I noticed Mike going like this. And I'm going, well, what's he doing? And it took me a while, and I realized he was posturing the same as he saw that rabbit, in the picture. Well, that's cool. I thought that's pretty neat idea. Is that our door? Is that our weather?
That is.
And then a few months later, I noticed we were watching TV or something, and he would sit, and he was posturing after me. When I would cross my legs, he'd cross his legs. If I put my hand up and scratched, he put his hand up and scratched. Well, that really scared me. That got me thinking, well, I better watch what I do and change what I do. So you do learn a lot. I learned a lot from just the things that he needs. I'm sure most of you know by now, your children have an incredible sense of humor. My sense of humor is just amazing. So I draw a lot of strength from that as well. So let's talk about legal stuff. unless y'all want to talk about other things. We can talk about sports, we can talk about anything you want. Typically what I like to do is talk about the nuts and bolts type of things. Like I said, we talk about a number of topics, and obviously I can't get too deeply into them, but I would like to at least mention them so that you have some familiarity and you know what they are. The first thing on my list is guardianship, and I don't know how big of an issue that is, especially for those of you with younger children. You're probably not facing guardianship until for a few more years. Anybody?
That's around 18, isn't it?
Typically at 18 is when guardianship comes into play. Some of you have teenagers, so it's not that far away. Under Kentucky law, a person is considered a minor and under the custody and control of their parents until the time they turn 18. At age 18, you are automatically presumed to be emancipated. That means you make your own decisions for everything. I don't know how here it is in Davis County, but I know in Jefferson County, the Jefferson County school system sends out a letter to all parents that says, once your child turns 18, you're no longer going to be able to sit in on IEP meetings and anything else unless you are guardian or power of attorney for that child. And that usually scares everybody. And I get a phone call from a frantic parent saying, what do we do? What do we do? I learned that from Magic School Bus. Anybody remember Magic School Bus? That was a great show. And a little girl in there kept yelling, what do we do? What do we do? What do we do? Usually that's what I hear. What do we do? There are two options under Kentucky law, and I'll talk about power of attorney later, but under guardianship, there is a legal definition of disability which is different from a medical definition or a practical definition of disability. The legal definition of disability is the inability of a person to make informed decisions about their day-to-day affairs, such as living arrangements, financial arrangements, medical arrangements, those kinds of things. That decision is a decision that our legislature has said that only a jury can make. If only a jury can decide whether or not a person is not able to do those things. Interestingly enough, we're the only state in the country that uses a jury to make that decision, but our legislature in its wisdom decided that was too important a decision to leave to anybody else. So I'm sure it's the same here. In Jefferson County, they have a 6-person jury trial that decides whether or not a person has the ability or inability to make those kinds of informed decisions. Frankly, with Down syndrome, it's kind of borderline. We have several young adults who are capable of making those decisions in an informed way. And then obviously there are several others who are not. And so there is sometimes a question on that. Not always. It just depends on how well a person functions.
Their IQ would have to be pretty high, wouldn't it?
Sure. That's why I say it's, it varies from person to person. The process is usually fairly daunting to people. I'll run through the process of guardianship real quickly. A petition is filed with the district court, and in Jefferson County, we're fortunate that they have a separate court just for disability. Do they have that here? Anybody know? Do you have a separate,
Yes, I think so.
separate guardianship court?
I think so, yeah.
That works out really well, and because it allows the clerks there to become more specialized and learn about that. But nonetheless, once a petition is filed, the petition is a document that contains the who, what, when, where information. The basic information about who the individual is, where they live, what their disability is, that sort of thing.
Where do you obtain
file
the,
that with the court too?
That's filed with the court. Yeah.
Once a year.
Well, what you're talking about is annual report, and that comes later.
Yeah.
I'm at the very beginning at this point.
where do you obtain the petition from? A lawyer?
The court clerk will have those. That's a printed form. I don't think those are even available online. There are some forms that are available at the what's it called? It's the court's website. I should know that, but I look at it every day. I keep thinking of the website. But I don't think the petition is one of the online forms. But you can obtain that form, and it's easy to fill in. It's a simple fill in the blanks form.
Is it ALC?
I'm sorry?
ALC?
ALC, yeah. Once that petition is filed, the court appoints 4 separate individuals. 3 of them are called the interdisciplinary committee. That's a psychiatrist, a psychologist, and a social worker. Each of those 3 individuals will interview or examine, if you will, the person they call the respondent. That, in our context, it would be your child. From their own particular discipline, the psychiatrist usually administers some standardized testing. The social worker interviews the person from how well they interact with other people, things like that. Once those interviews are completed, a report is filed with the court, and that report is given to the jury when the time comes for the hearing. Typically, one of those 3 people in the interdisciplinary committee will testify at the hearing as well. It's up to the court of how many people actually testify, but frequently, if it's very clear that the person is going to be found disabled or recommended to be found disabled by the interdisciplinary committee, only one person ends up testifying. So it's really not a long hearing process. Whenever I say jury trial, I know that scares everybody, but it's certainly nothing like anything you see on TV. There's no haranguing and screaming and all that kind of stuff. The 4th person who's appointed by the court is called a guardian ad litem. That's usually an attorney that's appointed off of a list that the clerks keep. I'm on that list for Jefferson County, and I do a lot of that sort of work. The guardian ad litem's job is simply to make sure that protect the rights of the respondent. Almost 99% of the time, it is not an adversarial role. You're not there to undo everything. You're there simply to make sure that the process goes properly and that the interests of the respondent are met. When I'm a guardian ad litem, frequently I'll have a person tell me, I don't want a guardian, and so I'll tell the jury, they don't want a guardian, but usually the jury, through the other reports, finds that the person needs a guardian and will find that the person's disabled. The jury only says yes or no to the question of disability. Is the person able to make informed decisions, or are they not? Once the jury makes this decision, the jury is excused, and then the court will appoint the guardian. The guardian is typically whoever applies to be guardian. In most cases, that's a family member, either a parent or a sibling. Many parents are worried that the state will come in and not let them be guardian or something. I don't see that happening. I would tell you not to worry about that. Absent some horrendous, terrible situation, it's just rare that ever happens. Typically, the state is only appointed when there is no one there. No one wants to be guardian, and that's when they bring the state in. So I don't like people to work out of fear and that sort of thing. Once a person is appointed, that person is typically appointed to be what they call a full guardian or a partial guardian. Full guardian exercises all of the rights on behalf of the respondent. Once a person is found disabled, they call them the ward. That terminology comes from Old English law, but it's still around. So you have a guardian and a ward. If a partial disability is found, then the court will spell out what rights the guardian exercises and what rights the respondent is allowed to keep. That's pretty rare. I won't see that very often. You see that more in cases where a person's disabled, say through some other thing, like a car wreck or something, and they're not able to do certain things. Like usually it's medical or financial. but they're able to take care of their personal life, things like that. In the Down syndrome context, it's either all or nothing usually. We did have an instance a few years ago where a young lady wanted to get married and her mother liked that idea, so we went to court and petitioned the court to allow the lady to make her own decision about marriage or non-marriage, and the court agreed to that, and they did decide to get married. But that's a pretty unusual circumstance. Once you're appointed guardian, then you're required to file annual reports with the court. That's what you were mentioning. Those are usually lots and lots of fun, aren't they? I get more complaints about the annual reports than any other thing. People hate to do that. And I will tell you that usually in our office, my wife is the one that gets to do those. So she can tell you more about them than I can. That's pretty much it as an overview for guardianship. Anybody got any questions about that? Okay.
How long before they turn 18 do you need to start that process?
Good question. There's no set rule about that. You can file as early as about 45 days before they turn 18. But there's no set rule. You could wait till they're 22 and file if you want. I mean, there's no set rule. But if you think that that's going to be an issue, you want to file earlier rather than later.
And another issue is that a lot of them goes to school till they're 21 years old.
Mm-hmm.
That's
Yeah,
another issue.
that's right. Usually it's the school system that prompts it, because they'll send that letter out I was talking about and say, if you want to be in the IEP meeting, you better be guardian. And so that starts the ball rolling. The other side to the coin of guardianship, that I mentioned it earlier, is a power of attorney. Anybody know what a power of attorney is? Power of attorney is a written legal document that's voluntarily entered into, whereby one person gives another person the right to do things on their behalf. They're used every day in business, when you do real estate transactions, or each of you should actually have a power of attorney with your spouse, so that your spouse can do things on your behalf, or not. Maybe we recommend that you do. But a power of attorney is a document that can be used as an alternative to the guardianship if, and that's the big if the person signing the power of attorney, and in this case we're talking about our Down syndrome children, if they are able to comprehend the nature of the document and understand what they're signing. A power of attorney requires a certain mental competence to be able to sign and understand that document. Having said that, we've done a number of power of attorney documents for young adults with Down syndrome where I believe that they are capable of understanding the document. My personal philosophy is that I don't believe that a person needs to be able to read every word in the document, because they're long and wordy and they're full of legalese. That's what we do. We put hearing aboves and wherefores and all kind of fancy words in there. But if the person can explain to me what the document means, and I think that they comprehend that, then I'm happy to let them sign that document. And I've done a number of those. We use a little less technical language with a power of attorney document like that. And I put extra language in the notary clause saying that I've examined this person and I believe that they understand the document. Typically in a notary you get a little one line. This person acknowledged this before me, and that's it. I add that extra language, and since we've been doing that about 8 or 10 years ago, I've not had one challenged. I mean, everybody's accepted those documents, including the school system. And so I urge parents to at least consider that before the guardianship, on the idea that it's the less burdensome alternative. A power of attorney is not court structured. It involves no court reporting or bonding or anything like that, and it's worth considering. And so, if it doesn't work, you can always go back and file for the guardianship. The big risk with the power of attorney, That's not the right word. Are you taking notes? Don't put down big
Yes,
words.
I do.
The concern with the power of attorney is that it's a voluntary arrangement. It takes nothing away. Remember I said with guardianship, the person loses their civil rights. They don't have the right to act on their own behalf. However, with the power of attorney, if I give a power of attorney to someone, I can still do everything I was going to do before. I keep all of my rights. So, if you have your son or daughter sign a power of attorney document, you're allowed to do things on their behalf, but that don't mean you can stop them from doing something they want to do. Let's say they want to buy a car. Everybody likes cars, you know. If someone were to get a hold of that person and say, here, come over here, sign this card, you know, and that could be held as a legally binding contract, you know. We don't see that very often, and frankly, I don't see that as that big of a risk. That's why I wanted to say it's not really a risk in a sense. Our son Mike is with us all the time. I don't worry that he's going to go out and buy a car, you know. And I don't know, that's up to each family whether you think that is a risk or a concern. And so I think that the risks for him are very, very low if he were to have a power of attorney versus the guardianship. Everybody understand where I'm at? I'm afraid I'm confusing that. But I normally ask people to at least look at a power of attorney before they do the guardianship. And if they decide that either the individual can't comprehend the document or that the risk or the concern is too great that they might actually be taken advantage of, then you have to go back and go through the guardianship route. But it's worth thinking about.
Is the power of attorney a one-time thing, or do you have to redo it annually? Or
No, power of attorney is, once it's signed, it's considered valid. Yeah. Banks are notorious. We got any bankers in the room? Banks are notorious for not wanting to honor a power of attorney if it gets more than 3 or 4 or 5 years old. But typically, they'll have you sign a little separate affidavit saying that it's still in effect or something like that. But, no, and once it's signed, it's good indefinitely. I have a number of people who have power of attorney documents that are 15, 20 years old, and they use them every day. So, yeah.
Which one's more popular? I mean, do you see more power of attorney or guardianship?
Well, I don't know that there's I have no way of gauging that. His question was which one's more popular. And, you know, in my mind, the power of attorney is more popular because I push it. I think it's a great idea. I think it's worth considering because of the restrictions that come with guardianship. With guardianship, you're tied to court. You've got to get court approval for things. You have to do court reports to the court every year. And in some cases, you have to actually have a bond. With the power of attorney, you have none of those things. So you're free to act as you see fit. You are a fiduciary. You're handling assets or monies on behalf of someone, but nonetheless, you have a lot more freedom and you don't have the court restrictions. So that's why I like the power of attorney as the first step. And then again, if it doesn't work, you always have the guardianship to go back to. Guardianship is much, much, much more difficult to undo. If you have a guardian, if a person is found disabled and a guardian is appointed, there is a way, but it's extremely difficult to get the guardianship undone and get the person to have their rights granted back to them. Power of attorney can be revoked at will. If it works out that the power of attorney is not working, or that the person who is given the power, let's say they get at odds. Let's say somebody does something that they don't like, and the person says, I don't want him to be my power of attorney anymore. And then it just kind of goes, the relationship goes south, you know. That can be changed. You can revoke the power of attorney and appoint someone else. There have been instances where we've done that. I normally counsel people not to do that lightly, but it can be done. With guardianship, it's much, much more difficult. You have to actually go back through the interdisciplinary team process and that sort of Okay. Usually with guardianship, I mention conservators, only so to tell you that conservator is something that happens very rarely, and I wouldn't concern myself too much about it. Conservator is usually a person appointed to manage finances for an individual, but nothing else. Finances only, and that person's given the title of conservator. Another corollary with that, and some of you may already be, a Social Security payee. That's got nothing whatsoever to do with guardianship or conservator. That's only where Social Security recognizes a person to receive funds for someone getting Social Security. What ends up happening is that when you go through these things, you go through guardianship and Social Security, you end up doing all of that. So you're wearing all these different hats, doing different things. But as a legal matter, they're all very separate. Now that we've talked about power of attorney a little bit, there are two types of power of attorney. One is the general power of attorney. I recommend that for spouses. I would recommend for each of you to have a power of attorney to your spouse and from your spouse back to you. That's two separate documents. I also strongly recommend to families, if you have other children who are over 18, that they have a power of attorney to someone, because children, young adults, have a need for that more than they do other things. And I've seen a number of instances where they didn't have that, and let's say they were injured in a car wreck or something. The parents would have to go actually through the guardianship process in order to handle affairs for that injured person. And if they would have had the power of attorney document in place, it would save them a lot of worry and frustration and just general grief. So I strongly encourage just a general power of attorney, which is separate from what I was talking about for using for a person as an alternative to guardianship. In our office, we also do what we call a medical or a healthcare power of attorney, and it's simply a power of attorney that's restricted to medical things. It's for more serious medical situations. If a person needs open heart surgery or whatever, brain surgery or whatever, it's easier to have that in a separate document. We combine with that power of attorney the living will requirements. What person can state whether or not they want to be kept on life support or not, those kind of things. To me, it makes sense to combine all those together into one document, which we call a healthcare power of attorney. You can have a living will separate from that, just as a separate document. Anybody here got a living will? You know what those are? Y'all don't go to hospitals much, do you? You walk in a hospital, first question, you have a living will? A living will was created by our legislature back in the, late 80s, early 90s. And it is simply a statement of intent of whether or not you wish to be kept on artificial life support or not, whether you wish to be kept fed artificial fluids, and that sort of hydration, that sort of thing. The big thing about living wills is that they are extremely narrow in the scope of what they actually cover. A person has to be permanently unconscious, such as in coma, and two treating physicians have to say that this person has no hope of inner recovery whatsoever. If you have a pneumonia, doesn't count. If you broke your arm, doesn't count. It really has to be a very serious, what they call terminal condition. Typically, you see those things happening in famous cases. Probably the most famous one was about 8 or 9 years ago down in Florida called the Schiavo case. It was a young lady who, I think she had an aneurysm, and her husband and her parents got into a dispute about whether or not they wanted to remove life support, and I don't know if y'all remember that. Well, she did not have a living will, and so nobody was really sure. Her husband took the position that she did want to be removed from life support. Her parents said no, she didn't, and they fought all the way to the Supreme Court over that. I think twice they fought all the way over. It was not happy and not pretty. Had she had a living will, none of that would have taken place. I mean, it would have, whichever way she chose, it really doesn't matter because you check I do or I do not. It would have solved all of that aggravation and fighting over between the family.
She's the one that laid there for 15 years. Is that right? 15 years in the nursing home?
I don't remember how long it was for her. I don't think so.
The Quinlan?
Yeah, I think that was Quinlan out in Oklahoma or something like that.
Oh.
But usually when you hear about it, it's a famous, it's some big case like that. In the normal day-to-day, you don't ever hear about it. But that does exemplify why we need to have them, and I think it's a good idea to have one. The term living will is something somebody dreamed up. It's really a statement of your intent of how you want to be treated should you be in that situation.
I think that's a good thing.
Oh, yeah.
I think that's a good thing.
Very, very much. Okay. I've kind of run a few things together, but we've covered guardianship, conservators, Social Security payees, and living wills. Everybody good with all of that so far? The next thing, I guess, is just a regular will. Last will and testament. We always print that real big up at the top of the document, make it sound real foreboding. A will, in its simplest form, is simply your statement of how you want your property to be handled after your death. A will covers personal property, that is, property owned by you. You can state whom you would wish to receive the property. What it doesn't cover is property that is either owned by you jointly or owned outside of the will. And what I'm thinking of is what for a lot of us is a major part of our property. 401ks, IRAs, life insurance, those things all have separate beneficiary designations. They are typically not covered under your will. So it's important that you understand that and make sure that those items, whatever they are listed the way you want them to be listed. Life insurance is one that shows up a lot. And the typical case where it comes up is a person will take out a life insurance policy, name their spouse or their parents as beneficiaries. Time passes. If they name their spouse and then they get a divorce and they forget about it, they get remarried, 30 years later, they die, what happens? First spouse's name is still on that life insurance policy. Guess who gets the money? That usually doesn't go well with the second spouse. They don't like that much. So it's important to keep those up to date. We see that happen relatively common. Another part of your will is a statement of who you would like to have appointed as guardian for minor or disabled children. And you can say, wait a minute, didn't you just say it was about property? That's one of the fun parts. Our system of laws we have in Kentucky came from the Old English Common Law. Everybody remember that from 6th grade civics? The Old English Common Law was the statutes and the laws, actually it was court cases that were determined over time in England, and when Kentucky became a state in 1792, it adopted the English Common Law as its system of law. So all of those court cases became the foundation for what we have in our Kentucky statutes. Some of the inheritance and estate laws we have are word for word the way they were 300 years ago. Who inherits property if you don't have a will, for example? By the way, that statute is interesting. If If you do not have a will, who gets your property? Who gets your property? You die today with no will. Where's
Next
your
of
property?
kin.
State.
State, yeah, a lot of people believe the state. A lot of people believe their spouse gets their property.
Next of kin.
Next of kin, that's correct. But the way the state has it listed is next of kin is first your children, if you have children. Second, if you do not have children, your parents are considered the next of kin. If you do not have children or parents, it goes to grandparents, your grandparents. If you do not have living children, parents, or grandparents, it goes to brothers and sisters and their children. And then next on the list, if you don't have any of that, then your spouse comes in. And the reason for that is that was to keep the old English farm in the family name. It was to make sure that it didn't leave the family. Our Kentucky statutes still say that to this day. They have included also what we call dower and courtesy rights, so that spouses are entitled to half of personal property and 1/3 of real estate. It still doesn't sit well with spouses if they're told, you get a half of the property, the other half is divided amongst the children, which happens occasionally. So, if you don't want that result, you have to have a will. In your will, you're free to say whatever you want. The best person to demonstrate about wills is Leona Helmsley. Anybody remember Leona Helmsley? She was the heir to the Holiday Inn, is that what it was? Holiday Inn fortune. She left a will. In her will, she died and said, all of my fortune is to be held in trust for my little pet puppy dog.
For real?
Her children got zipped, got nothing. Children didn't like that. They were mad as hell. They went and filed suit with the court. And the court said, Leona knew exactly what she was doing. She liked the dog better than she liked you. The dog wins. And the dog to this day is living well somewhere up in New York. On the death of the dog, then it goes to the children. But they have to wait until the dog. I'm sure that dog is a bodyguard. I only bring that up to make the point. You're free to make your will out however you wish. No one can coerce you and tell you you have to do a will a certain way. If you want to leave it to your puppy dog, that's okay. Just be prepared.
I mean, okay, she left it to the puppy dog, so when the dog died, then the children come in.
Yeah, then the children get it. Yeah.
Okay.
But one of the statutory requirements of the will is that it be done freely and voluntarily, and without coercion, and that's what she did. She set it up the way she wanted to. You also have to be of what they call sound mind. Well, sound mind simply only means that you know what you're doing. Well, she knew exactly what she was doing. And I'm not recommending that you do that, but I want you to know you can if you want to. There was another case out in California about 30 years ago where a lady did the same thing for a pet canary. And, you know, just if that's what you want to do, then that's okay. I mentioned you also about you can name a guardian in your will, and the oddity about that is that under the Old English common law, children were considered property, and that's why you put a guardian in your will for your children, where everything else is all about property. Those laws are still in effect today, too. Those of you who have children under 18, did you know that you're entitled to all of their earnings? You can make them hand over your paycheck.
Say that again?
Try that. That'll go over bad. That, nonetheless, what you're saying in the will is that you wish a court to appoint a certain person to be guardian. I don't mean to confuse you. Only a court can actually appoint a guardian, so in your will you're saying this is who I want the court to appoint, whoever that is. We normally recommend strongly that you have a person and then an alternate as well, so you have at least a couple of people there in your will on who you would wish to be guardian. A will also has to normally name a person to be in charge of your estate. We call that person an executor or executrix. That's one of the few vestiges of Latin that's still in our law. We have a few Latin words. One of my favorites that people like is called per stirpes. That's two words. It's P-E-R, and the second word is S-T-I-R-P-E-S. And what that means is, if a named person in your will, let's say I leave something to Kay, and Kay predeceases me, then anything I leave for her will go automatically to her children. That's what the per stirpes doctrine means. And the Romans figured out how to say that in 2 words. The English lawyers took 3.5 pages. So you'll see the per stirpes written in lots of wills. Just see that Latin floating around there.
What if you don't have a will or don't name a guardian?
Mm-hmm.
What happens to the child?
Typically, the statute you're talking about as far as guardian is concerned, if you don't name a person, anyone can go apply to the court to be guardian, and there is a statutory preference for family members. And so if a person does not name anyone, then any other family member or interested party can go file an application to be appointed as guardian. The court will hold a hearing and make a determination on whether or not that person should be or should not be appointed guardian. It is required that notice of that hearing go out to all other interested parties. So if you have a child who's disabled and you've got 4 other siblings, all 4 of those siblings get notice of that hearing and have a right to show up and say yes or no, whatever they believe. That sort of thing. Is that what you were?
Yes.
Also, I'm going back to wills. In a will, typically families can make trust arrangements if they wish to do that. That's not a requirement. It's simply a thing that's where you would set up a trust if you wanted to do that. It's kind of beyond the scope of our discussion here. Those trusted and set out in wills are typically for anyone that the maker of the will believes should have property held in trust. That's not necessarily the same type of trust as the special needs trust that we're going to talk about after a while. But frequently you see trust arrangements set up in wills. I think I've covered all of the real fundamental things. You can put anything you want in your will. If you want to leave your favorite coin collection to a certain party, you can list any specific property you wish. Or you can make it general and say, I want to leave 1/2 of my estate to this person and the other half to that person. One big issue when you have a child with a disability is how do you leave property for that child? Under Kentucky law, the only way to do that is to leave that property to a special needs trust. Typically, the language we put in our wills is the person says, I intentionally did not leave anything individually for my child, not because I don't love them, but because I've set up this trust to make sure that they're taken care of. And I put that language right in the will, not because I don't love them, because the old advice, if you read the advice from 15, 20 years ago, the legal advice was disinherit your child. Well, that sounds terrible. You don't really want to do that. And you're not really disinheriting your child if you've set up a trust for them. But nonetheless, you see that in some old textbooks and some old articles, and I don't subscribe to that at all. So I put that language in so that you can handle that. Any questions about wills? Okay. One thing I didn't mention in wills is that, I'm always happy to tell my clients I'm not a financial planner, so I don't get into the kind of planning where people do actual estate planning with financial things. I normally refer them to a financial planner for that. So any questions about tax questions and things like that, we usually bring in some expert on those kind of things. Well, let's talk about special needs trust. Anybody here have one? Okay.
I have one.
First thing I want to tell you is a special needs trust is not any of the things we talked about before. It's not a will, it's not guardianship, and it has nothing to do with those things. It's important that you understand that, because a lot of the terminology overlaps in these things, and I hear people all the time intermingling that terminology, and I understand that. There's a lot of different things there to try to keep track of. Special Needs Trust in general started about 1993 with some federal legislation. I can give you this quotes on the legislation if anybody really interested in it. But I'd like to give you a little bit of the history of why they did the legislation. It was an overhaul of the Medicaid program as it was back in those days. In the middle 1980s, early 90s, the financial planner, were there any accountants in the accountants did all this, see, it wasn't the lawyers. They had this plan called the Medicaid Trust, and it was a great plan. What they would do is when people would retire, they would set up a Medicaid trust. They would put all of their assets, all of their property in this Medicaid trust. They would put the house, the bank accounts, the RV, the boat, everything they had, would all go in a Medicaid trust. Then they would move to Arizona or Florida and say, I don't have anything. Give me money. Give me Social Security. I don't have anything. And it worked. They would get a big check from the government every month and have all this other stuff. And somebody complained and said, wait a minute, that's not fair. They're double dipping. They got all these assets, and yet they're getting Social Security. Congress agreed with it. Congress said, no, we're not going to do that anymore. And that was this legislation in 1993 called the OBRA legislation. It's Omnibus Budget Reconciliation Act. And in that law, they said, we're not going to allow people to have Medicaid trust anymore. You cannot have assets in a trust and still qualify and be eligible for Medicaid type benefits. Buried way down in that legislation. If you ever read federal legislation, it's really exciting. I mean, it will absolutely keep you awake for about 47 seconds. Buried way down in section 1696, it says, but if a person has a recognized disability, we will allow that person to have a trust and be eligible to receive Medicaid type benefits. That was the birth of the Special Needs Trust. And it's helpful to understand that because they put a lot of strings around it, certain rules, and understanding why they did that helps you to understand some of these strings. Number one, only a parent, grandparent, or a guardian can establish a special needs trust. Siblings can't do it, next door neighbors can't do it. Recently, there's been a change in Kentucky law allowing the district court to establish a trust if there is no parent or grandparent available. But that's a pretty small group of people. If you have, we've had many situations where we had an older disabled person, and by older I mean a person in their 40s or 50s. And mom and grandma are all dead, and we didn't know what to do until the new statute came into being. It was difficult. Another one of those strings, and it's an important one, is that trust assets cannot be used for day-to-day food and shelter, support and maintenance. Is that a siren?
Tornado sirens.
Where do we go?
It's a tornado.
Are we good?
Severe
Or do we need to go
weather.
somewhere?
It's severe weather. not tornado.
He's got, his phone says tornado warning, so I don't know if there's.
Well, I'll leave it to y'all, whatever you think's best.
There's a tornado warning, yeah.
Where's the kid?
I'm trying to think.
Bathrooms.
Bathrooms or kitchen, everything else is
Or the
windows in this
kitchen,
building.
yeah, windows. I just happened to be at,
So you can see.
IOU Southeast, and I was walking towards the bathroom, and then it says tornado shelter. It never entered my
Here?
mind about, no, IOU Southeast in Jeffersonville. The bathrooms, I guess young students don't think of those things. You hear the sirens, and it's in the bathroom.
Is it- See, we were talking about the different rules and restrictions of setting up a special needs trust. Let's see, we have a court reporter read back what my last question.
I could go back and look at the tape.
The gist of what I was saying was that in setting up the framework for the special needs trust, Congress also set certain rules in place so that people couldn't do the abuses that were going on back under the old Medicaid trust. And that's what the idea of the one I was talking about was you cannot use trust funds for direct support and maintenance. That's food and shelter. And that one always causes people to stop and think a little bit. You think, wait a minute, food and shelter, isn't that what we kind of need? The theory is that that's what the Medicaid is for. And when I say Medicaid, that's usually SSI. It isn't always, but 90% of the time it is. SSI is supposed to be used for direct support and maintenance. And so, in theory, you get your direct support through the SSI, and the trust is used as for what they call supplemental needs. And in the early days of special needs trust, there were a lot of people would call them a supplemental needs trust. If you look at some of the stuff online, you'll see people talking about a supplemental needs trust. Well, that's what they're talking about, the same thing. You really don't find the term special needs in the statutory language. That's just what it's come to be called over the years. To me, the best word is the word enhance. Trust is an enhancement of the lifestyle of the individual. Things like clothing, vacations, recreational things, telephones, iPads, all those things are typical trust expenditures. Whereas the SSI is for rent and your daily trips to, what's the big grocery store here, Kroger, Publix, Walmart. Yeah, go Walmart. That's what SSI is supposed to do. Now, in reality, it doesn't work that way very well. Anybody who has a child on SSI comes quickly to realize that SSI is not enough to live on. I forget what you might get, $400 and something a month. Okay. You couldn't live on that in a given month, and so there is an exception that if all of the assets are used up in a given month, then you can use trust funds as a supplement. But you've got to be careful with that. Some of the other rules is that the beneficiary of the trust can have no access to or rights concerning the trust assets. Again, as a practical matter, I'm not saying Mike could care less about what's in that trust and what's not in that trust. It doesn't matter to him. But as a legal matter, that's very important. He has no right to say anything about how the trust is invested, managed, or spent. Any of those decisions. In fact, the trust has to be discretionary with the trustee. The trustee has to make a decision on all expenses. The reason for that is that by cutting off the right of the beneficiary to trust assets means that the beneficiary does not have ownership of those assets. Because of that, stays eligible for Medicaid. The Medicaid eligibility section says that a person to receive the Medicaid benefits, again, I'm talking about SSI, has to have a recognized disability and have assets of less than $2,000. That $2,000 threshold is a moving target. At any given time, you cannot have more than $2,000. That's exclusive of clothing and personal possessions. But things like bank accounts, assets, real property, $2,000 is the limit. That $2,000 was set in 1993, has not been changed, and I don't expect it to be changed. So it's a hard thing to stay under $2,000. We have a number of clients where the person managing the trust has a difficult time staying under $2,000 because they don't use that much money in a month. If their child, son or daughter is living at home, they just don't spend that much money. And so sometimes they go over the $2,000 simply because they don't know what to spend it on. And so I tell them, big screen TV, something big. At any rate, you understand some of those rules about the trust and the trust restrictions. I do want to make sure you understand that there are two fundamentally different types of special needs trust. And it goes back to the establishment of the legislation. Under the federal legislation, they call them a first-party special needs trust or a third-party special needs trust. First party and third party refer to the source of the funding for that trust. In other words, a first party special needs trust is funded with assets that belong to the beneficiary. A third party special needs trust is funded with assets that came from someone other than the beneficiary, and none of the beneficiary's assets are placed into that trust. The difference between those two is that on the termination of that trust, first party special needs trust, the assets of that trust are subject to what they call Medicaid reimbursement or Medicaid recovery. So on termination of that trust, all of those trust assets go back to Medicaid to repay Medicaid for any benefits that that beneficiary received during their lifetime. Third party trust does not have that restriction. 97.2% of the trusts that we do in our office are the third-party variety. Those are the trusts that you use when you're doing planning in conjunction with the will and say, I want to leave X number of dollars for my disabled child, and when that disabled child dies, I want those trust assets to go to my other children or to some charity or church or maybe GRADSA, whatever you want to do with it. But nonetheless, you have that ability with a third-party trust. You do not have it with a first-party trust. Sometimes people say, well, why ever bother with a first-party trust? Why would you even do that? Well, it just depends on the situation you've got. If the beneficiary already owns assets at the time the trust is established, you don't have a choice. You've got to place those assets into a first-party trust. It's not uncommon for us to do both trusts for a family. They'll have both of them running side by side. Now they look identical and they operate identically, but the difference is on termination of the trust. Another one of those rules is that the special needs trust must last for the lifetime of the individual. Therefore, termination of the trust is the death of the beneficiary. There's exceptions to all this stuff, but by and large, that's what we're talking about. True story. Last Monday, I went out and saw a lady who called me and said, my husband passed away 2 years ago, and it's time for me to start planning. I have a son. He did not have Down syndrome, but he was disabled. And she said, I need to put some arrangements in place for him. I said, great. How old is he? She said, 56. And I thought, you're a little late. Should have been planning a little sooner. And that brings me up to the next question is, when do you start doing this? When do you start doing the plan? Don't wait till your child is 56. Don't do that. That's not a good idea. I have done special needs trusts for children who are 6 months old. There's no set rule on that. You can do it at any time. Most people tend to get around to it around that age 18 when they're going through guardianship and it starts making them think about those things. It's really more in when you feel comfortable with putting things in place. Some people struggle with that. Some people are ready to do it right away, and that's going to be different for every individual. When you're comfortable enough to where you're ready to set up a trust, you need to think about a couple of things. All trusts have 3 individuals, 3 titles. You have the person who establishes the trust. We call that person, I call him the grantor. Some attorneys will use the term settlor, and sometimes you see trustor. All 3 of them mean the same thing. I like grantor. That's what I use. The trust is established for a beneficiary. Special needs trust can only be for one beneficiary. You cannot have multiple beneficiaries. If you want to set up a trust for your disabled child, and then other trusts for your other family members, you have to have a different trust for those other family members. And then the person in charge of the trust is called the trustee. You can have more than one trustee. I would not encourage going more than 2. Occasionally I'll have families that say, well, I've got 3 children and they all got to be in charge. I'll do that, but I don't want to be around when the fun starts. If those trustees ever get into a dispute, they're going to end up in court. You know, it'll just happen. So 2 trustees is fine. I see that a lot, but beyond that, I wouldn't encourage it. The trustee is the person, again, remember what I said, trustee has absolute discretion in determining how trust assets are invested and how they're spent. Therefore, it's real important who you pick for your trustee. Almost all parents make themselves the first trustee, and I think that's great. I encourage that. Even if you don't have a lot of assets, or any assets, if your trust is going to be funded somewhere down the road with life insurance, which most special needs trusts are, that wasn't the roof coming in, was it? Okay, we're good. We're good. You still, it's a worthwhile idea to have the trust established and make yourself a trustee just for the educational part of it. To me, that's as valuable as anything. Once you get a trust established and you're the trustee, even if you have $500 in there, you could at least try on what it's like to be a trustee and how this thing works, because at some point you're going to be educating the next person to come along, and that's really valuable. That's part of the big decision. Families struggle more over that one decision than any other thing that you can come up with. Who comes after me? What do we do? Who do we pick? In our family, it was easy. We chose our daughter. We didn't even ask her. We just said, she's going to be in charge. I found out later that didn't go over very well with her. She called me and said, Dad, she's now 34. At the time we did Mike's trust, she was 20 and a sophomore in college. She said, don't ever, ever, ever put a college kid in charge of a small child in a large sum of money when they're 20 years old. Don't do that. That's not a good idea. And so I tell people don't do that. But nonetheless, who you have if you have that's all you got in your family, and who you rely on. You need, and there's no rules about who you pick and who you don't pick. You need to have someone that you have extreme confidence in that will make the right decision, who understands that they're going to be in the role of a fiduciary, they're going to handle someone else's money. They're in complete charge of it, but it's not theirs. That's a big concept to get over. I don't know, I'm sure you have them here, but we've got a gambling boat up close to us. You've got to make sure you have somebody that doesn't have gambling fever, you know. You just have to think those things through. One of these handouts talks about that a little bit. And there's no right or wrong answer to that. I mean, it's just a comfort level you have to have when you pick that person.
What do you do if you don't have no one? Can the bank be in charge?
You can have a corporate trustee. That's a good question. Did everybody hear her question? If you don't have a family member, every bank has a trust department, and they're all excellent. And anytime you wanted to name a bank as a trustee, that's a fine idea. Most families in the special needs context stay within the family if they can, simply because of the finances. Banks charge a fee for that, and they want to keep it within the family. But that's, I have no problem with the bank being trustee. They're going to do a very professional job, and the only thing is you don't have that close family connection. If you have a family member that's saying known the child since birth, that's the only little thing. But that's not a legal reason not to do it. Would be fine as a trustee.
Well, I experienced something 27 years ago. Me and my ex-husband we lived out of town, and he was working on a job. Larry was 8 years old, and from the time Larry was born till he was 8, he was very sick child. Anyway, my ex-husband got hurt on a job severely, severe brain damage, left him violent. During this time, he was hospitalized in Brokaw, Illinois. And at that time, and I'm telling you God's truth, none of my family, nor his family, wanted no part of Larry.
Yeah.
That was very difficult to deal with. Me, 350 miles from home.
Yeah, I'm sure.
Very. I had to hire somebody, my neighbor,
Mm-hmm.
to take care of Larry until we got back home.
Right. And it does happen if you have a very small family or family's not getting along with,
We had large families, but nobody wanted no part of it.
When you're selecting a trustee, you just have to take those things into account. And again, that's going to be different for every family. Now, when you select a trustee, it's not the end of the world. If after a couple of years you decide I have the wrong idea, you can undo the name a trustee. You can take back the nomination of a trustee. Special needs trust, one of those rules I talked about, have to be irrevocable. And irrevocable scares everybody. But that doesn't mean you can't change trustees. Irrevocable really means assets that go in a special needs trust have to stay in the special needs trust and be spent for trust purposes. You can't put $1,000 into a trust and then a week later decide, whoops, I need new tires. I'll use that $1,000. Can't do that. You can do something else with the tires. That's the irrevocable.
That's just for their personal use only. Trustees.
For the trust use.
Yeah.
A trust is a separate legal entity. I hear lots of families will set up a trust, and if their son or daughter, they'll say, well, that's their money. Well, it's not. It's the trust's money, and that's an important concept to keep in mind. The trust is a separate legal entity. It can own property, can buy and sell property. It pays taxes. It's all done through the trustee, of course, but legally the trust is a separate legal entity. And it's important to understand that. Let's see. Talk a little bit about just the nuts and bolts of what goes into trust. Typically, our trusts run about 18, 20 pages, single space, and they cover a number of different topics. At the outset, of course, you have the declaration of the trust and saying I'm intending to make this trust and why you're doing it. You also have to cover the Medicaid rules and make sure that you state in the trust that the beneficiary has no right to the trust assets, has no control over trust assets. There's a clause in the trust that's required called a spendthrift clause. Spendthrift means that the assets of the trust cannot be used for any debts or obligations of the beneficiary. Beneficiary cannot go down to Walmart and say, or Menards. We were in Menards today. Great place. Hey, here we are.
Go. Get it.
That's all right.
Go. Thank you. That's for 15-year-old.
I apologize, ladies and
That's
gentlemen.
all right. That's why we're doing all this. Beneficiary cannot go somewhere and say, I want to buy that, and my trustee will pay for it, send the bill to him. Trustee is not responsible for that. We actually had that happen once, and there was a fellow who would go to a pipe shop, and he would order these pipes and say, oh, my trust will pay for those pipes. And the trustee called me and says, do I have to pay for that pipe? And I said, no, you don't. So we ended up having to work out an arrangement where they paid $10 a month or something for the pipe till they got it paid off. Because it was an expensive pipe. So the spendthrift clause is an important part of it. The reimbursement provisions have to be in there. If it's a first-party trust, you have to state that all assets of the trust go back to the Commonwealth of Kentucky or any state from which the beneficiary received benefits. If it's a third-party trust, you state that there is no reimbursement requirement. You also have to have what I call the ultimate distribution provision, and that is what happens on termination of the trust. We put a provision in a trust that says that you can use trust assets for any final expenses, last administration expenses, funeral, suitable marker, those kind of things. Assets left after that can, in a third-party trust, can be left anywhere you choose. You can be left to family members, to charities, churches, whatever you think. The only rule is they cannot go back to the donor. That goes back to that Medicaid trust idea. You can't put money in the trust and get it back. So you can leave it anywhere you want, you just can't get it back to yourself if you put monies in it. If the trust is funded with life insurance, that's usually not a problem. So I want to clarify one thing. A first-party trust, I said those assets go back to Medicaid. If you have a situation where there's money left in the trust after Medicaid gets paid back, then those funds can go back over towards the family members. But that doesn't happen very often. Usually when Medicaid is involved, it's a big number and it takes up all the money. But it could happen. I've got an estate right now where we reimburse Medicaid like $56,000, and there's another $18,000 left over to go back to family members. So it does happen sometimes. I hope I'm not confusing y'all.
So in other words, you're saying that if, like my son has Medicare.
Mm-hmm. Not Medicare, Medicaid. Medicare is for health insurance. That's not reimbursable. But the Medicaid, if he gets SSI, is.
Well, he draws Social Security disability for his father.
Okay. That's
Medicare.
That's regular disability. That's not reimbursable. So he's not going to have a reimbursement issue.
So in other words, say like if something happened to me and I've got this trust fund set up and he goes to a nursing home,
Mm-hmm.
can they dig into that trust fund?
No. Did y'all hear a question? If our son were to go into a nursing home, none of this applies while the
They can't
beneficiary is
come in and
living.
take nothing out of his trust fund?
Yeah, that would only happen on his death. And if he's getting regular Social Security, not SSI, there's not a reimbursement requirement there at all.
So they couldn't take nothing from his
Probably not,
trust?
yeah. Yeah, you just need to make sure that you have something in line so where those funds can go eventually.
Oh, I do.
Okay.
Yeah, I do.
I mean, y'all understand what you said? Because that's a good point. Because you're thinking 30 years down the road on these things. It's totally crystal ball gazing. There's no right or wrong to this. You're looking way down the road and hoping you got it right.
Well, I've taken out some accidental insurance on Larry, and I got a letter in the mail from them saying that if, say like if he was in an accident, say like if he died, he'd pay like $62,000 if he got killed in a car accident. Okay, or say like if he just got hurt and had to go to the hospital, they're saying that Medicaid can come in and take that money.
Possibly.
So, that's what they're saying. I talked to the guy the other day, and I had this out on Larry since 2009, this accidental policy. And they're saying because he has Medicaid, that they're gonna send back our money and cancel his. Now, I mean, I have to cancel it, they can't, I have to do that. But they're saying that if he got hurt, then Medicaid is gonna come in and take this money.
Well, Medicaid would have a claim for anything that it pays. See, that's two different things we're talking about. Medicaid is one thing.
Yeah,
Social
Medicare is
Security
another.
disability is a different thing.
Yeah, but you see what I'm saying?
Yeah.
So you know, if Medicaid's gonna come in and take this, I said, like if he got hurt, you know,
Mm-hmm.
and they're gonna come in and take the money.
They very well might, yeah. I mean, that's something you would have to have looked at individually by somebody to see what the best way to handle it is.
So I just told them, you know, I'd just cancel the policy.
Might be the best thing, yeah. Another thing a lot of people put into the trust is provision for living arrangements. I want to make sure you understand, as I remember, like what I said, you cannot use trust funds for room and shelter and that sort of thing. But you can make sure that the beneficiary has a certain standard of living, and that you can have them. Frequently, we'll say that I want my beneficiary to have the same standard of living as that they enjoyed with me, living in our home with me, something along those lines, so that you can make sure that the standard of living is there. The trust normally has a section talking about the powers and duties of trustees. Because trustees are required to have discretion, what we normally set out is a series of guidelines on how to use that discretion versus black and white, do this, don't do that kind of rules. And that's a section where we, in the trust that we do, we normally put out as much information as we can about the individual beneficiary. We tailor it as much as we can to that person, what they like to do and what they don't like to do. We had one family that had, for the whole family's lifetime, they had box tickets or whatever you have at Green Bay Packer Stadium, whatever, and they wanted him to have access to those tickets. And so that's in the trust. They can do that. And another family who had the same thing up at the Kentucky Speedway, and so they wanted to make sure that he had access to go to the races anytime that he wanted to go, because that was important to that person, to that young man. And that's going to be different for every child. Some people like music, and some people could care about just whatever. Try to tailor as much as you can and know that kind of information about in the trust. There's tax provisions that need to go in there. One of the areas that always causes a lot of confusion is called a generation skipping tax. Families who have large amounts of wealth like to set up in their estate plans where grandparents will leave assets to grandchildren, skipping the level of children because that saves some taxes. Well, guess what the IRS does? We got a tax for that. It's called a generation skipping tax. So if transfers are made from one generation, skipping one down to the other, there's a special tax for that. Under current law, those transfers have to exceed $3 million before the tax is imposed. And so, depends on how much you got in the trust. I always put those provisions in the trust because I figure everybody's going to make $3 million somewhere along the way. Special needs trusts have kind of a quirk in there. It's possible that you could have a generation skip. Remember we said the trust is for the lifetime of the beneficiary. So you set up set up a trust for your beneficiary. In our family's example, my son Mike, for his lifetime. If everybody in our family is deceased and on his death, the assets go down to our grandchild, that's a generation skip. So potentially, it's not likely, but it's potential out there. So I put those generation skipping provisions in the trust. At least it makes me sleep better. Everybody understand the idea that there is a potential for it? It's not likely, but it's a potential for it, so it could happen. Another idea that a lot of families like to have, and it's not a requirement, but it's something worth talking about, is an advisory committee. These trusts are private trusts. They're not public records. They're not governed, or they don't have oversight by courts or any agencies. The Kentucky Medicaid Department will look at the trust and say, yes, it is, or no, it's not a special needs trust. But after that, they don't get involved in it. Courts do not get involved in it. So it's a private trust, and you've got a trustee out there on their own doing whatever they got to do, using their complete discretion. Some families are comfortable with that, some are not. I'm very comfortable in our trust, having my daughter do that. Some families would say, well, why don't we get them some help? And so they establish a thing called an advisory committee. An advisory committee can be any number of individuals who know the beneficiary and can meet and advise the trustee on issues of trust management or expenditures or whatever. And you can build into the language of the trust how strong you want that to be. You can make it as strong as having the advisory committee be able to replace the trustee at will, or you can have it be merely advisory and nothing else. Mommy. That's completely up to you. We typically require advisory committees that they should meet at least once a year, more often if need be. Committee members are usually volunteers, other family members. One thing I like about the advisory committee is that it gives you an opportunity to have people on that committee who genuinely care about your child and who will have their child's interest at heart. It also gives you an opportunity to have people on that committee who will be your future trustees. You know, you may have some 9-year-old running around the house that's going to grow up to be the CPA someday, is going to be in charge of your trust. You know, you can watch them over time. And when they get old enough, and if they're interested enough, put them on the advisory committee and see how they make decisions and how they process information. And so there's lots of good things you can do with an advisory committee. It has lots of flexibility. I invariably recommend that advisory committee meetings be held somewhere in the Bahamas. Nobody's ever done it, but I think it's a great idea. And I think they ought to take their attorney with them, but nobody ever does it.
I'll be on anybody's committee that wants me to.
Typically, they are volunteer. Advisory committee members do not receive a salary. They just do it because they care about the individual. But it's a great thing to think about, and it's a good idea. It gives you lots of flexibility. What I've just run through is kind of the nuts and bolts of a typical trust, all those things. By the time you get through all that, you're at 18 or 20 pages, and so it just turns out to be quite a bit in text. Anybody got any questions on any of that? You're allowed to ask questions. We like questions. One thing I haven't mentioned is the whole financial aspect of this. Again, I'm always happy to tell people I'm not a financial planner, so I don't do that part of it. But I know several of them, and I'm sure every family typically these days has someone who is a financial planner. You get into questions about how much money do we need, what's the right amount, and there's no real answer to that. There's no right or wrong to any of that. MetLife has a thing called a special needs calculator or something on their website, and you go through it, you answer all the questions, and at the end they'll tell you how much you got to have. It's a number that'll absolutely scare you. You know, they always come up with some huge number. So I'm assuming that means that the next button will be buy life insurance for this much, you know. But I don't know how you tell that. I don't know how you do it. It's just, you know, every family's gonna have to struggle and come up with an answer for themselves on what's the right amount. However, once a special needs trust is established, you can add funds at any time. You can own any kind of property. You can have real estate. You could buy an ongoing business and have it be owned by the trust, and so the income goes into there. You can own rental property. There's any number of things that can be done with that property. If you don't want to go that route, you can also contribute, you know, have $10 taken out of your check every month or something if you want to do that. There's no real rule on that. It's whatever each family thinks is the best way to do it. Having said all that, most people do it with life insurance or their estate through their will. That's 95% of what families do. If you happen to come into a windfall somehow, then you can dump some of it into the trust. But most families do it through life insurance or their estate.
I got a question for you.
Yeah.
Like with my son Larry, there's no one, you know, appointed guardian or power attorney if I should pass away.
Mm-hmm.
Then what happens? State comes in?
If no other family member steps
Steps up.
forward, then the state would be as a default, yeah.
Yeah.
I would encourage you to get somebody to kind of be in line that's worth doing, if you could. The last thing I think I want to mention about the Special Needs Trust is, under the statutory framework, it's really the only game in town. Any other kind of trust is not recognized by Medicaid as an exempt resource. If you set up a traditional living trust or a family trust, those things are nice, but those are not exempt resources under the Medicaid statutes. Trustees are not expected to operate in a vacuum. Just because you become trustee doesn't mean all of a sudden you're endowed with all this wisdom and knowledge. Most trustees are allowed to go get all the help they need. If you need an accountant, you go hire an accountant. If you need legal help, you hire an attorney. If you need a bookkeeper, you get a bookkeeper. Whatever you need, you can go out and you have the authority to go do those things. And that's important to know, because you don't have to feel like the world's on your shoulders. You can go out and do what you need to do, get the help you need. I think that pretty well covers most of everything. I'd still encourage any questions if anybody's got any. Going once? Going twice?
Well, I agree.
Okay, well, thank you all very, very much. I enjoyed coming here, and I always enjoy coming, so I'd like you back. We took a tour of Menards this afternoon, and we don't have one of those in Louisville. We need one. Yeah.
I did have one question.
Sure.
So you have 2 children, and I guess the only thing I was trying to understand is if you left the assets and everything, you worked with a financial advisor, and you left it to your daughter rather than setting up a special needs trust.
Mm-hmm.
So the special needs trust is set up for, like in your example, for Michael or ours, for Chapel. If we left it to our other children, legally, what's the difference there?
Y'all hear his question? It's a good question. What he's asking is, couldn't you just leave all your property to some other child and say, here, take care of my kid? You know, essentially.
If you trust, yeah, if you
Sure,
have a trust.
they do that. You run some risks when you do that. And the risk is this: if you leave all the property to a non-disabled child, okay, a brother or a sister, those funds go into that person's name personally. So once they get those assets, they have to pay taxes on it, on the in earnings, and should something happen, let's say they go through a divorce, 50% of that money is going out the door, or potentially at least. If they get sued by creditors, well, that money can be reached by the creditor. So you run some risks in doing that. Even if the person has every 100% good intent. You know, if they say, I want to take care of that, I'm not going to use it for anything but little Johnny over here, you know, there's some risk involved in doing that. And so we don't really encourage people to do that. The trust cannot be reached by creditors, cannot be reached by other people looking for monies. It's isolated, and it's much safer, you know, by putting it in a trust. Putting it in some other kind of trust, like a family trust or a living trust, doesn't keep it as an exempt resource. The special needs trust is the only way to keep it as an exempt resource. And so that's why we encourage people to use that format. And then there's just a plain old risk that the person you leave it to has some faults and squanders it away. You know, you run that risk, and there's nothing you can do about it. And so that's really why we encourage, we think the trust is the best way to go. To answer your question, is that what you're thinking?
So most people, like attorneys, specialize in special needs, or is this something that
You probably want to go with someone who mostly does special needs cases, is that right?
I don't know how it is here in Davis County. I don't know many attorneys here. In Jefferson County, there's probably only 5 or 6 of us that actually do them. Most of attorneys don't even know what they are.
So you really need someone that knows. I mean,
Yeah.
It's not something you just learn and
Yeah.
I mean,
Well, yeah, I mean, it's not, you don't see it day to day, you know. I mean, I got into it because of Mike, but otherwise, before that, I didn't know what it was. If he had to come along, I still wouldn't know what they were, I thought. But yeah, I mean, that's typically.
and what's the average cost of setting something up, or how is it built?
That's a good question. Again, it really depends on the complexity of what we set up. Typically, when we do a trust, we do, in addition to the trust, we do wills and the powers of attorney and the living wills and all that together. It all ends up being a package deal. Frequently, we end up doing both trusts at the same time. So you'll have 2 trusts, and that's 2, we put them in binders, so that's 2 full binders with all the attachments and the supporting documents and the instructional materials, and then the wills, powers of attorney, and so on. So it could get complicated. Probably the top end would be about $5,000. Most of them run between $1,500 and $2,000. I can't give you an exact number, but something like that. If we have to go to court, it's going to be closer to 5. If you have no family members and you have to file an action to have the court establish a trust, that's a little more complicated. And that happens occasionally, but if mom and dad come in and set up a trust, it's not really that complicated.
Carla, do you know of anyone in Davis County? I know in years past, they discussed it, but.
Not right off, I don't.
George Thacker, I think, or one of the Thackers. We had talked to them several years ago. We had never actually signed a dotted line or anything. We didn't want to pick an executor and all that stuff, so we just quit.
Difficult decisions, aren't they? It's tough to pick those decisions.
There used to be an attorney here in Owensboro that had a Down syndrome brother, and I cannot think of his name.
Yeah. I normally, when I do a trust, what you said reminded me of something. When I do a trust, I'll fix up a draft of the trust and mail it to the family because I know they struggle over that.
Huh.
Who should come after us? Who's going to be the next trustee? And I won't hear from them for 6 or 8 months, and then they'll call me up and say, "Well, we're ready now," And I know they've struggled, and they'll call me with questions. And I certainly understand that. I've been in those shoes, and I understand it. So I have no problem with somebody waiting 6 or 8 months and then saying, "We're ready," for a year. We did one last week. The drafts were all dated 2009. But that's okay. I'm all right with that. They have to work through some things, yeah.
Do you do them for outside of Jefferson
Oh,
County?
yeah, sure. I do them all over the state. I do them all.
Do you have to go to Louisville to meet, or
Well,
typically is that if you do one, or do you do
we've signed trust in McDonald's, We did one in the middle of a basketball game somewhere. We'll make something work, you know, we can make it happen. That's just a matter of trying to work out the logistics of getting together. You know, I'm always happy to do that. Any other questions? Well, thank you all again. You've been a great audience. I don't think I've ever given a talk that we got a little siren break. That's pretty cool. If everybody got handouts, please take them. They're just ideas to make you think about things, is all they really are. And I encourage questions. If you think of something tomorrow or next week, call me up or email me. I'm slowly being dragged into learning how to text, probably my daughter, but you can send me email. I'm real good on email. I'm slowly learning how to text. But if you think of something, fire away. I'm more than happy to answer it. Thank you.
Thank you.